As stated, we are here today for a final trial on this matter. In this case, only involves retroactive child support. And there are some exhibits that were sent in. So, Mr. Brantley, you didn't submit any exhibits, is that correct?
That's correct.
All right. And Attorney Terry, I have three exhibits. P1, the DNA results, P2, respondents' financials, and P3, the email exchange.
Yes, Judge, those are all our exhibits.
Okay. They were pre-admitted. They will be admitted at this time.
Thank you, Judge.
Okay, you're welcome. So you all will have 15 minutes aside that will include any opening and closing statements, should you all choose to make them. Attorney Terry, would you like to make an opening statement?
Just a very brief opening, Judge.
Okay, go ahead.
Judge, this is a very straightforward case. The evidence today will show that there was a child subject to the suit that was born Alondra. The evidence will also show that Mr. Brantley knew about Alondra, that he avoided admitting to the parentage of Alondra, and then the evidence will also show that Ms. Rodriguez bore all of the expenses for Alondra from the time that she was born up until present day, where there is a current support order. And that will conclude my opening, Judge.
Thank you. Mr. Brantley, would you like to make an opening statement? An opening statement is just you telling me what the evidence is going to show on your side of the case.
The evidence will show, and I'm not sure what I don't know if I can address Mr. Terry's exhibits, but
well,
that
it's
evidence,
an opening statement. So as the evidence is presented, then you'll be able to do cross-examination of it. But for now, just an opening statement is you telling me what the evidence will show in regards to what you're asking me to do. You can also waive opening too and wait until it's your opportunity to speak, and then you can tell me whatever it is you want me to know.
okay. I guess my opening statement would be then, I did not know about Alondra until Alondra contacted me when she was age 16 years old. I had no idea. Her mom knew where I worked. She knew where I lived. She did not, even to this day, she has not officially notified me. The person that officially notified me that Alondra was my child was Alondra herself. So I'm not sure what evidence they have to show that. It is not in the three exhibits that they spoke on. But I believe that is the end of my statement at this time.
Thank you. And Alondra is 18, correct?
17.
She's getting ready to turn 18 in October.
Yes, Judge.
Yes, ma'am.
Okay. All right. I have it. All right. Attorney Terry, you may call your first witness.
At this time, we will call the petitioner, Ms. Elvira Rodriguez.
Okay. And you may proceed whenever you're ready.
Thank you, Judge. Ms. Rodriguez, could you please state your full name for the record?
Elvira Lucia Rodriguez de Leon.
And Alondra Rodriguez is your daughter, correct?
Yes.
Has Alondra lived with you for her entire life?
Yes.
Were you and Mr. Brantley in a relationship around the time that Alondra was conceived?
Yes, we would go out, we would talk, and we would go out.
So officially, when did Mr. Brantley learn that he was Alondra's father?
When I was pregnant, I called him to tell him that I was pregnant.
And how did he react to this phone call?
Not very well.
Could you tell the court if there was any conversation that you and Mr. Brantley had surrounding you letting him know that you were pregnant with Alondra?
When I called him and I told him that I was pregnant, I told him that he was the father of the child.
And did he have any response to that?
He just said, okay, but that was it, not much.
Okay. Was there a DNA test done in this case, Ms. Rodriguez?
Yes, when we came here with the lawyer and the court sent us.
And that DNA test established Mr. Brantley as the father of Alondra, correct?
Yes.
So, from the time that Mr. Brantley learned that he was the father to Alondra to present day, has he paid any child support for Alondra?
No.
Has he paid any health insurance, or has he provided any health insurance or medical insurance for Alondra?
No.
And there is currently a temporary order in place that requires him to provide child support and medical support for Alondra. Isn't that correct?
Yes.
Has he contributed anything voluntarily to Alondra?
Yes, when he met her, he got her a Christmas present and he took her to the store to buy shoes and clothing for school.
Okay. So regarding the current temporary order that was entered on February 2026, Mr. Brantley was ordered to pay roughly $994.99 per month. Is that correct?
Yes.
And that was based on Mr. Brantley's current income, correct?
Yes.
Pass the witness, Your Honor. No further questions.
All right. Mr. Brantley, this is now your opportunity to ask any questions that you may have of mom based on her testimony.
Question one, did you notify me after the birth of Alondra that she was in the world now?
No.
So I just want to be clear, after the birth of Alondra, you never notified me that she was here.
No.
Okay. Besides, oh,
Oh, she was still speaking.
I'm sorry.
Adelante, señora. I didn't tell you I no longer had your phone number.
Mr. Brantley, you may ask your next question.
Okay. Did you know where I worked or where I lived during these 16 years until Alondra contacted me?
Yeah. Adelante, perdón. Yes, but I did not look for you because you said you didn't want to know anything about us when I told you that I was pregnant.
I like to say out front that that's a lie, but anyway.
Mr. Brantley, you can't do that.
Oh,
It's questions only.
All right, I'm sorry. I'm no lawyer, but I'm sorry.
Okay.
So and again, I want to be clear. Uh, and you did not notify me for 16 years. You did not look for me at all for 16 years. And well, that's the question.
I did not look for you because you didn't want to have anything with us. And Alondra called you on the phone when she was 15, not 16.
Okay. So all right. So at 15, did I reject you or did I embrace Alondra?
You embraced Alondra.
Okay. So uh, besides the Christmas present and school shopping, did I ever assist in anything Alondra had coming up, like trips or anything else like that?
Trips? No.
Did, you said no, so I never gave you $500 for a trip
Oh,
or
n- so So no trips. He has not gone on trips on me, but on trips with me. But he did give Alondra some money as a present. When we have not taken any trips together, but when we took a trip last year, he did give Alondra some money so she could have money to spend.
no, no. Well, I was told it was something for school. I don't know if it was a trip that she was going to take. I'm not sure what it was. I didn't really ask questions. I just did I not provide some type of money to help her with the trip multiple times?
It was for the trip, it was a gift and the shoes and the Christmas present. And that's it, as far as I remember. That's all.
Judge, can if I don't think she's telling the whole truth, is there anything I can do about it?
Well, when it is your opportunity to tell me what you want me to know on your
Okay.
what it's called a case in chief. So after you hear Mr. Terry say that he rests, that means that it's your opportunity to speak. So at that time, you can tell me everything you want me to know, including what you want me to know about her testimony.
Okay. Uh,
Do you have any further questions of her?
Stand by. I'm trying to do this off of my head, so I'm sorry if it's taking a minute here. That, now, okay. You say that I had nothing. You said that I didn't want anything to do with you and Alondra. Was that before she was born or after she was born?
Before she was born. After she was born, hold on a second. Después de que nació. After Alondra was born, he agreed to see her and he has seen her.
16 years later, correct?
Correcto? 15.
15 years later. I'm sorry.
15 years because that is when Alondra was ready to look for him.
So Alondra found me, or Alondra notified me. Oh, I'm sorry.
Sorry, the interpreter was just asking her to wait until you finished asking the question.
Okay. So Alondra notified me. How can I say this? So if you needed assistance, why did you not notify me after the birth?
Because as I said, you did not want to know anything from us, so I didn't bother you.
Oh, okay. Let me ask you, did you or did you not tell my wife, you knew when we got married 13 years ago?
Objection, Judge. Relevance.
Sustain.
Okay. Can I plead the relevance of this case, Judge? I don't know if
Well,
that's proper.
I already sustained the objection, so you'll just ask your next question.
Or rephrase, right? I watched a little bit of court TV, so, or I could rephrase.
Well, not that one because I
Ah,
sustained it as to relevance. So that means it goes outside of the scope of what we're here for today.
okay. How about this? Mr. Terry said that we were in a relationship. I disagree with that. This was more of a one night stand, basically. Is that true or false?
That is false because we went out several times and you came to my place of work several times, and my coworkers knew that you and I were dating.
Oh, that's.
And his friends also knew that we were going out.
Judge, that is a bald-faced lie.
Mr. Brantley, I've already
I
told you
know.
you can't do that.
God damn. I mean, okay.
You cannot use profanity in
Oh,
court, Mr.
oh,
Brantley.
okay. Judge, that is a lie. How about that?
Okay,
That
Mr.
is a
Brantley,
lie.
how about this? I don't want to derail what it is that you're trying to do. Let's refocus here. Remember,
Okay.
the issue that is before me is retroactive child support. So anything that does not have anything to do with retroactive child support and whether or not you should pay it or the amount that she's requesting, stay away from those questions. I only need
Okay.
to hear evidence involving that.
Judge, I am not familiar what I need to prove that then. The only thing I can prove right now is I didn't know. Yes, she told me. No, we were not in a relation. I don't know if this is the time to do it. If it's not, then stop me.
Well, no, it's not.
Yes,
It's not.
Okay.
Because it doesn't even matter if you all were in a relationship or not. And actually, the family
Okay.
code doesn't even look that deep into it. The
Okay.
child is here. There's a DNA test on file that confirms you are the father. So that triggers your legal obligation to pay child support. Okay. At this point,
Okay.
you're essentially trying to plead, if that's what you're wanting to do, that retroactive child support, either you shouldn't have to pay it or you shouldn't have to pay the amount that she's requesting. That's essentially what you would be doing in opposition to what she's asking for, because that's what she wants.
See, I don't know the ins and outs of Okay, or I don't know if you're obligated to tell me, what do I need to prove to, or how can I stop that? I know you can't
I
say
can't
it.
answer that.
Or,
I can't
I
answer
know you
that.
can't.
We're at final trial. You would have had to ask an attorney. You would have had to have asked an attorney about that prior to today.
Yeah.
So what you could do is, this is an option for you. If you don't have any more questions to her as it relates to the retroactive child support, you can say, Judge, I passed this witness, and then she'll be asked any redirect questions by her attorney, and then
Okay.
her attorney will call his next witness. If it's you, you'll be able to get your opportunity to speak.
Okay. All right. I have a question.
Yes, sir.
Um, all right. Here's the question. If I was not notified until Alondra was the age of 15, so she was alive in the world, for 15 years, and you did not tell me uh, and didn't give me the opportunity to support you, support her, then why do you think you deserve retro today? Why are you trying to last minute this thing
I'm going to
instead
object,
of
Judge Compound. He already asked a question, and he asked another question right after that.
Oh, okay.
Sustained. So you have to ask one question at a time, Mr. Brantley.
Okay. You can answer the first question then.
Okay. Repeat the first question for her. Just the first question.
First question. Okay, here you go. If it's true that I said I wanted nothing to do with Alondra, why did you wait 15 years? Well, you didn't notify me. Why did you allow Alondra to wait 15 years to notify me?
Why did I wait 15 years? Because that is when she was ready to know who her father is and to get to know him and have a relationship with him.
Okay, next question. If I didn't want to know her, and if I did say that, why would you even consider offering that up to Alondra to get to know me? Why didn't you tell her that?
I don't understand the question. I don't know what he is trying to ask exactly.
Okay, the question, let me clarify. If, and I do mean if, I said I didn't want anything to do with Alondra and you, why would you tell her or allow her 15 years later to make that decision for herself? Why didn't you tell her, well, this is what he said, and leave it at that?
I'm going to object again, Judge Compound. That was two questions.
Oh, freaking name.
Sustain. Yeah, you asked her two questions. Would you like for her to answer both?
Yeah, yes, ma'am. Yes, ma'am.
Okay, so the first question was, ma'am, why would you tell her or allow her 15 years later to make that decision herself?
Because it came from her heart. She wanted to have a relationship with him, and I was not going to get in the way. If she wants something, I'm not going to get in the way of her getting to know her father.
Okay. And the second question was, why didn't you tell her, well, this is what he said, and just leave it at that?
A conocerla, porque tengan una bonita relación como padre e hijo, es bueno para ella.
Because if she wanted to know him and he agreed to get to know her, they could have a nice relationship and it would be good for her.
Okay.
Okay. Then, all right. Does it not make sense what you're saying? Why would you think that we would have a good relationship if I was the guy that said, I don't want anything to do with you? Please make that make sense.
Objection compound. That was 3 questions.
Okay.
Sustain.
I understand, Judge, on that one. That's fine. Okay. As far as the retro, I'm trying to stick to the retro. I'm trying to think of questions. So why do you think you deserve retro if you waited 15, 16 years for her to notify me?
Objection, Judge. Speculation.
That's not. Okay.
Hold on 1 second. Let me read it back. First version. Trying to see if he's still talking. You think, do you? Overruled. The question was, why do you think you deserve retro if you waited 15 to 16 years for her to notify me?
I'm
Judge, can I-
only following what the law states, and the money is not for me, it is for his child.
If the money was for the child, why did it take you 50? You're not answering the question. Why did you take 15 years to notify me?
Objection, Judge. Asked and answered. I think she's answered that question 3 times.
Sustain.
She did not.
She answered it. It just wasn't probably the answer you were looking for. She said, I'm only following what the law states.
Okay. All right. Is there a way to get the proper answer out of her? I mean, because
Well,
what the law states is not. It's not a reason. It's just an excuse she's trying to use, in my opinion.
technically, that is her answer because the law says that you're entitled to retroactive child support. So if that's her answer, that's her answer. I can't force her to answer differently.
Well, I'm not okay. I was okay. All right, Judge, I'll pass.
Okay.
Pass.
Okay. Mr. Terry, Attorney Terry?
Yes, Judge. I just do have 3 quick points that I would like to make. Miss Rodriguez, excuse me, let me back up. Before Alondra was born, and I'm going to ask
Tell
you.
him his mic's not on.
Oh.
I can hear him. You can't hear him, Mr. Brantley?
Yes, ma'am.
Okay. Go ahead, Mr. Terry.
So before Alondra was born, did Mr. Brantley, excuse me, tell you anything about you giving birth to Alondra?
Counsel, can you please repeat the last part of the question?
Right, I'm sorry. Before Alondra was born, did Mr. Brantley make any comments about you giving birth to Alondra in the future?
You know.
I do not understand the attorney's questions. Can you repeat, please?
Plainly, did Mr. Brantley tell you while you were pregnant with Alondra that you should have an abortion?
Objection.
Okay, what is your legal objection?
What is the relevance of that question as far as child support is concerned?
Well, number one, well, if I may, Judge, number one, it goes to the fact
Whoa,
that
I didn't get a chance. I didn't get a chance, Mr. Terry.
well, the objection wasn't sustained yet or overruled on, so I can, right. So,
Mr. Brantley, I wanted to, I mean, you made a good objection. I wanted to hear what he was getting ready to say.
Oh, okay, Judge.
Go
I
ahead.
didn't have it out.
so
Okay,
Judge,
I'm sorry.
number one, I believe that the answer to this question would clarify the issue. It would better clarify the issue as to why Ms. Rodriguez waited so long to inform Mr. Brantley, and
Man.
it would also provide to the court that Mr. Brantley did have notice that Ms. Rodriguez was pregnant with Alondra at the time, which also I believe needs to be cleared for the record.
Objection.
Hold on, Mr. Brantley, you've already objected.
Well, I'm okay. I'm objecting to.
Okay, I muted you because you cannot talk at the same time that I am. You have to allow him to finish, and then I will rule on your objection. I was getting ready to rule on his objection. I mean, on your objection. I'm sustaining the objection, which means he has to ask the next question. So I agreed with your objection. Does that make sense? Okay. Now you can unmute yourself. There you go. Okay. Attorney Terry?
Yes, and just one last question, Ms. Rodriguez. As far as the amount of retroactive child support that we're seeking today, is it correct that you are seeking $23,879.76 in retroactive child support?
Give me a pen, babe.
How many years are you asking for?
This would be a 24-month, at the minimum, a 24-month period.
Yes, it is whatever the judge decides.
No further questions for this witness, Your Honor, and we are going to risk, but I do want to clarify that I would like to cross-examine Mr. Brantley after his testimony.
Okay, 1 second. Just to make sure that amount she was seeking, $23,879.76.
Yes, Judge.
Okay. All right. You rest. Mr. Brantley, now's your opportunity to speak. You can tell me whatever you want me to know about your portion of the case. You have 3 minutes and 37 seconds left. And Attorney Terry, you have 9 minutes and 17 seconds left.
Quick question, Judge.
Yes, sir.
The 23, they're looking for 24 months?
According to her testimony, she said it's at least 24 months.
Okay. Okay, so Judge, there's been a lot of half-truths going through Ms. Rodriguez, and I have to say Mr. Terry too. Me and Alondra, or me and Mr. Rodriguez were not in a relationship. I visited the restaurant that she worked in. We went out one time, and that time born a beautiful child. Alondra is a beautiful child. She's annoying, but she's beautiful. So there was no dating. There was no relationship in that. I think I've been robbed of 15 years of this child's life based on Miss Rodriguez's delusion, because what she told me, myself, and my wife when we first got together is something different than she's trying to say today. It amazes me that she can just sit there and allow it like that. It just amazes me. But anyway, Um, I do not think that the problem that I have with Retro, I don't disagree with Retro. I disagree with her trying to take it. Now, when Alondra came into my life, I did more than a few Christmas presents and you know a gift here and there. I did more than that, and I would have loved the opportunity to watch her grow for those 15 years that I missed because of Miss Rodriguez. It wasn't a decision that I made. As far as the abortion thing, I am a person of options.
Wait a minute. Hold on.
Okay.
I sustain your objection when he was asking about abortion. So if you're going to talk about it, that means he's going to cross-examine you on it.
That's fine. That's fine. I'm gonna cover it all. I don't care. You got 9 minutes, you said, right?
Well, here's the deal though, but I sustain his objection, meaning you said it, I sustain your objection. You said it wasn't relevant. So why would you talk about something that's not relevant?
I was just trying to cover all the lies that were told. Or not necessarily. They're correct that I did say abortion, but I was putting options out there. It wasn't like you're going to have an abortion. I was like, okay, I'm pro-choice. If you want to, that's on you. If you don't, that's on you. I've never said I didn't want anything to do with it. No, that's a bald-faced lie. If she would have showed up on day one of that child's birth and she would have showed up at my house when she has the address of, I would have embraced her 15 years ago. But she kept out of my life based on her decisions. And now it seems like she's trying to do this last minute thing and just, take all she can get. Again, I was absent in Alondra's life for 15 years. Okay. And by her decision, now she's trying to freaking force my hand through the government, also by her decision. I'm just trying to find an opportunity to have a decision in this thing myself, to help or not to help, But I'm done, Judge. Thank you.
You're welcome. Real quick, Attorney Terry, before you turn over to Attorney Terry, what did you mean when you said now she's just trying to take it? What did you mean by that?
Through the government. She's using you, Judge, and the state of Texas to dig in my pocket, basically. Instead of allowing me the ability to help my child, she's using you and the government of Texas to freaking basically take it. And that's a decision she made. And on top of the decision that she made to keep me out of her life, because I never said that. If she would have showed up to my house with that child in her hand, just like I embraced it when she was, 15, just like I embraced it when she was 15, I would have embraced it then. But she basically stole that 15 years from me based on the decision she made. And that's all I'm saying, Judge. So that's what I meant by that.
Thank you, Mr. Brantley. Thank you.
Thank you.
Yes, Judge, just a few questions. And I do know that you sustain the objection regarding the abortion. However, some of my questions do kind of hit on the abortion, but it's not really bringing it out. So I hope that's okay, Judge. But I'm just going to proceed.
Well, he mentioned it. So
right, Judge. So, Mr. Bradley, you did tell Ms. Rodriguez that she should have an abortion, correct?
I gave her the option to have an abortion.
So that means So that means you knew she was pregnant.
I didn't know anything. She told me she was pregnant, and I didn't know if she was or wasn't. It was almost as if, somebody came up and told you I have a gun. That didn't necessarily mean they have a gun. She said she was pregnant. I'm like, okay, again, pro-choice. If you want to have an abortion, I will help you with that, is what I told her. But I didn't know she was pregnant. No. Just because somebody says something doesn't make it true. I'm sorry, Mr. Terry. I'm sorry.
So just to get this straight, you didn't know she was pregnant, but you did tell her she should have an abortion. That's your testimony today.
That is not my testimony. My testimony is if she was pregnant, because I didn't know she was pregnant, because I was not in a relationship with her. And I gave her a choice. If she wanted to have an abortion, if she was pregnant, then I would help her with that. But I didn't know she was pregnant. No.
So do you normally just go and tell women that, they should exercise their right of free choice without knowing that they're pregnant or not?
It's not my decision. Like that's the definition of pro-choice.
Objection, Judge.
Oh,
Non-responsive.
damn. I thought I was
Sustain
responding pretty good.
after it is not my decision.
Okay.
So,
He's going to ask you another question.
Okay.
right. So you talk about how Miss Rodriguez didn't seek you out for 15 years, but I think from the evidence today, if you did know that she was pregnant, why didn't you seek her out for any of the time to communicate with your child?
Okay. I did not know she was pregnant. Number two, the one time that we went out on a date, I picked her up from the Walmart near where she stays. So I never knew where she lived. And I hate to say it like this, if some crazy chick told me she was pregnant, I didn't necessarily ever wanted to see her again. Because I didn't know. I'm like, this chick crazy. What's she talking about? So
But you did know where Miss Rodriguez worked at, correct?
yeah, I knew yeah. I frequented, and again, the dating is non-existent because I went to that restaurant a few times and ate with my coworkers. Doesn't mean that we were dating.
I'm going to pass the witness, Judge. I don't have any further questions.
Okay. Mr. Brantley, you have 40 seconds left. Is there anything else you would like for me to know?
Judge, I'd like to cover for 40 seconds, I guess. I try to be a stand-up guy. And that was taken from me because of Miss Rodriguez. And I do embrace the time that I have with Alondra now. Again, she is a teenager and she can try your nerves like nobody's business, but I enjoy it. And I would just love the opportunity to have a choice to be in her life and to help her, not be restrained and handcuffed by the government. But you have a job to do, and I guess I stand down, man.
Thank you, Mr. Brantley. Your time just expired.
Your Honor, the witness is asking if she can say something.
Attorney Terry, did you want to call your, well, you already rest. You rest. Never
Right,
mind.
Judge, I rested.
Does she have a question? Do you have a question, ma'am?
I want to say something regarding us dating. I was at my job working for 9 months.
Oh, that's fine. You all don't have to go that part. I don't need that for my decision making. Pursuant to the temporary order, Mr. Brantley, have you paid any child support under the temporary order?
No, ma'am. Okay, I've been in discussions with Mr. Terry about they needed to set up something in San Antonio.
Yes.
And I never received any indication back that they did that. So I can establish that account, or I'm not even sure what I'm supposed to be doing. But and my company won't take the temporary order, and I notified them of this also. They won't take.
Hold on 1 second, Terry. Go ahead, Mr. Brantley.
My company won't take the temporary order to allow her onto my insurance or to set up any kind of child support.
Why not?
I don't know. They just said they wouldn't accept the temporary order. I'm not 100% sure about that. And I notified, like I said, I notified Mr. Terry with this weeks ago. and hadn't received anything from that.
Okay.
So it's not a matter of I'm just not paying it. Is that I can't get the information from Mr. Terry and his law firm, so I can make this account in Austin or whatever it is, or get her on my insurance.
Judge, may I respond?
Yes.
So there was a temporary orders. Mr. Brantley did reach out to us and tell us that he was having problems with his employer, but to my understanding, we cured those problems. We sent him an income withholding order, which Judge Lee told us to do because that was probably the issue with the temporary orders. And as far as the OAG account, Mr. Brantley asked us for a number for his OAG account. We provided that number, which is usually the cause number. From there, I do believe that it's Mr. Brantley's responsibility to have that OAG account set up since it is his child support obligation. So any other characterization that it's our responsibility to do that and we haven't done that is inaccurate, Your Honor. We've done what we were supposed to do on our side.
Mr. Brantley, did you set up the account for you to get it started where it's coming out of your check?
And I hate to say this, okay, Mr. Terry said you sent me a what order?
An income withholding.
Income withholding. It's actually on file with the court. It was sent to your job back. Well, excuse me. It's dated April 1st, 2026. So it's gone to your employer. And it's probably been with your employer since April. So in order for them to withhold the state disbursement unit that you mentioned down in San Antonio, they have to have a case actually activated in order to take the money out of your check. So it's something that your employer would have, well, not your employer, you would have to do on your end with that number. Have you ever went online or called?
I went online and they told me to use the case number, and the case number wasn't enough digits.
Okay, did you use DF or did you use the zeros?
Yes, what?
Because if you use the DF wouldn't work. It'll be those zeros. It's like 12 digits or something.
Well, I'm not sure the digits, but I notified them, and I even talked to Ms. Rodriguez about this, and they were telling her the same thing, that I don't know if she needed to do it, or I'm not sure what needed to be done. It was not really clear to me. Ma'am, so it's not that, again, I'm not trying to not pay. It's just, okay, I'm just some guy. You know, if they're the lawyers, they need to tell me what I need to do 100% and not just send me an email and then I'm supposed to figure it out. It's just not,
well,
and I know,
they technically have to do that because they're representing Miss Rodriguez. So they can't do a dual representation of you all. Ethically,
I don't think it's, I'm sorry.
This is the issue. If you don't, if those payments aren't withheld from check, it's going to show on the Attorney General side that you haven't made any payments. Have you seen money coming out of your check yet?
No, ma'am.
Okay, so you need to get with your employer and see if they actually have the income withholding order. Because even if they had it and they were withholding, at least if they were withholding, the money would be held until one of you, between you and Ms. Rodriguez, actually opened up the case to let those funds release. But if they're not withholding, then that's an issue. You need to speak with your employer about that because it's going to look like you're behind.
So is today April 8th? No, April 12th.
No, today is May.
Today is May.
Yes.
So if my company had this thing for a month, wouldn't they not have taken the monies and held it until?
Unless something else is going on. It could be something else going on, which is why they haven't started withholding, because it doesn't take that long to withhold. But I don't know necessarily how your company's HR works, but you need to contact them to make sure that they actually have the income withholding order. Do you have a copy of it?
If he says he emailed me, I guess I do.
Okay, you need to give that to your employer because from what I see, it's been issued
I
since
did.
April
Yeah.
1st.
I gave them a copy of the temporary order.
Right. They need the
Yeah.
income withholding order too. So that's the reason
Okay.
why they probably weren't accepting the temporary order by itself because the temporary
Well, no,
order didn't actually give them the option to withhold.
I gave them the temporary order. This has been months ago now. I mean, around about the beginning of all this.
Right, but they need
So,
the income withholding order too. They need both
okay.
of them.
All right. I don't, in my opinion, Judge, my opinion. Again, I don't know what I'm doing here. This is the first time I've ever ran into this, and I don't think it's double representation. If they're telling for their client, if they want their client to get paid, there should have been exact instructions on what I should have did with that order. I think, I mean, if you're trying to get your client or my child the money that that's obligated to her, then they should have like broke it down to me what I needed to do. I'm like, I don't know. I don't know what I'm as far as that is concerned. What I'm supposed to do with my job. I mean, that's all I'm really saying. I'm saying is there were some balls dropped, but definitely not on purpose. Because
And I'm
again,
not judging you. I'm not judging you. I'm not here to say, who did what wrong. I just want to make sure the issue gets resolved, especially on
yeah,
your end, considering that income withholding order. It may not have reached your employer, or if it has, they haven't pushed it through to start
okay.
withholding money out of your check. So that's the main issue.
Here you go, Mr. Terry. Send me an email of what I'm supposed to do 100%, and I will get it done. I mean, that's all you had to do in the first place. I don't know why
Mr.
did it take
Brantley,
this long to get it done.
because I represent Ms. Rodriguez, Mr. Brantley.
Yeah, but if you represent Ms. Rodriguez, wouldn't it be prudent to make sure I know what I need to do as far as my company to get
If
her
you have
in
a
the insurance and the money?
if you have a child support obligation, wouldn't it be prudent to do your due diligence to figure out how to take care of that?
It would be faster if you told me because I don't know. Where am I supposed to look for
I
this
represent
information?
Miss
Okay,
Rodriguez.
so
I
Mr.
understand.
Brandon,
Yes, ma'am.
reach out to your employer.
Okay.
Make sure your employer has the temporary order as well as the income withholding order. Okay.
Okay.
After you make sure that your employer has both of those, contact the Office of the Attorney General with that case number that you have. And I believe the case number that you need is the one that begins with zeros.
Where would I find the zeros? Because that's not this case number, right? You're not talking about the.
No, not this one. So
Okay, so where would I get that case number from?
wait, let me ask mom. Miss Rodriguez, did you open up a child support case already with the Office of the Attorney General?
She said no. Well, she told me no previously.
I'm sorry, this is the interpreter speaking. I can't hear her if he's speaking over her. So I'm gonna need her to repeat. Hold on, this please, hold on. Okay, señora.
I know. I know.
We opened the account for direct deposit and we are in the process of doing the one related to the state.
Okay, so you haven't opened up an actual child support case, like you haven't gotten services from them. I'm just trying to make sure because that may be the issue too.
Nada en el sistema de ellos que tenía que volver a rellenar todo el papeleo.
No, because I spoke to the state and they said that they did not find anything in the system and that I will have to fill out the paperwork again.
That's the issue
Yeah.
right there. So,
Yeah.
Ms. Rodriguez, you have to actually fill out the application to open an attorney general case, then that's, and you can do all of this at the same time. You can open the case, send them the temporary order as well as the income withholding order. Um, so that is the issue right there, Mr. Brantley. She hasn't actually applied for services. So that's why your employer hasn't withheld any money. However, the temporary order is in place, which means that your obligation started at that time. So
That's fine.
technically, you would be behind only because the money wasn't being withheld. What you can do is pay up the money that is past due that you would technically owe since the temporary order. You can send once the services get started or before the services get started, you can actually are you in Dallas?
Yes, ma'am. Yeah, Dallas County.
Okay, so we have a court registry. I believe it's through the Domestic Relations Office that's here in the George Allen Courts building. And you can actually open up a court registry and deposit the money into there. So that way it will show a record of you actually making payments until the Attorney General's case is actually open. That way it
Okay.
doesn't look like you're behind. Does that make sense?
It makes perfect sense. It's
Okay.
may I say something right quick?
Not
This is
unless it's not unless it has anything to do with this, okay? Because
it has everything
I
to do
just
with it.
I just want to make sure, because you all are actually done. I'm getting ready to do my ruling. I just want to make sure that you understand before you get off of here what you have to do, as well as Miss Rodriguez, what she has to do. I want both of you to be clear on what you're supposed to be doing at this point.
Okay, is it? Well, she needs to do something and give me the numbers so I can do something. Is that basically
Okay,
what you're telling me?
I just said that. I didn't
Okay,
mean
I thought
to
that's.
say that.
I just wanted to repeat it. That's all.
Okay.
So when the second that, and I told her this, I don't know, a couple of 2, 3 weeks ago, when she told me the same thing that she needed to do an account or whatever. The second you get those numbers, give them to me so I can take care of my end. I told her this a long time ago.
Okay. Well, she knows now.
Okay,
She
that's
knows
all it.
now because I just gave her some clear instructions. Everybody knows what they're supposed to be doing moving forward. So, the court, first thing the court is going to do, the court is going to find that there is an adjudication of parentage. So it'll actually be in the order. Mr. Terry needs to be in the order that finds that Mr. Brantley is the biological father of the child through genetic testing. The court is going to find that retroactive child support is in the best interest of the child in the amount of $23,879.76, and that would be for the past 24-month period. That will be a judgment. Mr. Terry, you need a payout amount on here. And because the AG wasn't involved, that's the only reason why you wouldn't know the numbers right up front. But
Okay. I can try to grab that number for you, Judge.
if not, what I could do is what I could do is I can ask the Attorney General to
Okay.
the one that's assigned to this court to give me payout amounts based on that number. And that's just for child support, right?
Yes, Judge.
Okay, I don't see anything for retro medical.
No,
And I'm sorry, Judge, are you referring to the final order?
Yes.
I don't believe that we've submitted a final order yet, Judge, because we were waiting
No,
on.
not final order. I'm sorry. So this is final trial just about the retro child support. I don't see anything about medical. So you'll just need, I'll just have to get you a payout amount from the Attorney General based on the child support amount in itself. And Mr. Brantley, when you hear me say payout amount, you based on whenever you have a retroactive child support amount, there is a recommendation from the Office of Attorney General based on the amount of the child support that you owe and the interest that's calculated every month because it's a 6% interest that tags onto it. they give a recommendation on what you should pay in addition to child support monthly. So you're already at $994. Let's say your additional child support monthly is $100. So your child support amount would be that $994 plus that additional $100, which the $100 goes towards the arrears that you owe. Does that make sense?
Yes, ma'am.
Okay. All right. So as of right now, that's a judgment, Mr. Terry, but I will speak to the Office of the Attorney General and get a recommendation on a payout amount. And I have my coordinator email you. So you and Mr. Brantley can have those numbers for the final order.
Okay, thank you, Judge.
You're welcome. Is there anything further for the record?
No, Judge, I believe that is it from the.
At the conclusion of the hearing, the court ordered retroactive child support in the amount of $23,879.76 for a 24-month period, finding that retroactive support was in the best interest of the child. The court also took the unusual step of providing detailed practical guidance to both parties regarding the establishment of an Attorney General child support case and the implementation of the income withholding order that had been issued but not yet activated. The court discovered during the hearing that the mother had not yet opened a formal child support case with the Office of the Attorney General, which explained why the father's employer had not begun withholding child support from his paycheck despite the existence of a temporary order. Under Texas Family Code Section 158.001, an income withholding order may be issued as part of any child support order and directs the employer to withhold the ordered amount from the obligor's disposable earnings and remit it to the state disbursement unit. However, the income withholding process requires coordination between the employer, the state disbursement unit, and the Office of the Attorney General, and if the case has not been formally opened with the Attorney General's office, the withholding mechanism cannot function properly. This case illustrates several important principles in Texas family law. First, it demonstrates the court's broad discretion in determining retroactive child support. Despite the mother's prolonged failure to notify the father and despite the father's credible testimony that he would have supported the child had he known, the court found that the child's best interest warranted a retroactive award. This reflects the principle that child support is the right of the child, not the parent, and that a child's need for financial support exists regardless of the circumstances that prevented its earlier establishment. Second, the case highlights the challenges that pro-se litigants face in family court proceedings. Mr. Muhammad's frustration was palpable throughout the hearing, and his inability to frame his arguments within the statutory framework likely prevented him from presenting his case as effectively as an attorney might have. The court's patience and willingness to explain procedural requirements in real time reflects best practices for judicial conduct when dealing with self-represented parties, but it also underscores the reality that pro-se litigants operate at a significant disadvantage in proceedings governed by complex statutory frameworks. Third, the case demonstrates the practical importance of ensuring that all administrative prerequisites for child support collection are in place. A temporary order that exists on paper but is not implemented through the income withholding process provides no actual financial support to the child and creates a growing arrearage that can compound rapidly with the 6% annual interest that Texas law allows under Texas Family Code Section 157.265. The court's decision to walk both parties through the steps necessary to activate the support system, while technically outside the scope of a final trial, reflects a pragmatic judicial approach to ensuring that the child actually receives the support to which she is legally entitled.